McDonald and McDonald. The appellant, Fiona McDonald, suffers from a personality disorder. In 2005, with the assistance of a loan from CHL secured over the property, her parents, the Respondents, bought a house for her to live in. The Respondents granted the appellant a series of assured shorthold tenancies, ASTs, of the house, the last of which was granted in July 2008 for a year. The Respondents failed to meet payments due to CHL, who appointed receivers. As was their right, the receivers subsequently served a notice in the name of the Respondents on the appellant, seeking possession, and in due course issued proceedings in the county court in the name of the Respondents for possession of the house. His Honour Judge Corrie heard the case and held that the court was not required to consider the proportionality of making the order for possession sought, and, as Section 21, subsection 4 of the Housing Act 1988 required him to make an order for possession against a person holding under an AST who had been served with an appropriate notice, he had to make such an order. If he had been entitled to consider proportionality, he said that he would have dismissed the action. The appellant appealed to the Court of Appeal, who dismissed her appeal, and the appellant now appeals to the Supreme Court. The Supreme Court unanimously dismisses the appeal for reasons given by Lady Hale and myself. The appeal raises three questions. First, whether a court entertaining a claim for possession by a private sector owner against a residential occupier should, in light of Section 6 of the Human Rights Act and Article 8 of the European Convention on Human Rights, be required to consider the proportionality of evicting the occupier. Secondly, whether, if the answer is yes, the 1988 Act could be read so as to comply with that conclusion. Third, whether, if the answer to both questions is yes, the trial judge would have been entitled to dismiss the claim for possession, as he said he would have done. On the first issue, it's well established that a residential occupier can raise the question of proportionality of making an order for possession against him or her, where the party seeking possession is a public authority within the meaning of Section 6 of the Human Rights Act. See Manchester City Council and Pinnock. The appellant contends that the same reasoning applies to a private sector landlord because the court, which has to grant the order for possession, is itself a public authority for the purposes of the Human Rights Act. This court's view is that a residential tenant cannot contend that Article 8 would justify a different order from that which is mandated by the contractual relationship between the parties, at least where there are legislative provisions which balance the competing interests of private sector landlords and residential tenants. Otherwise, the European Convention would be directly enforceable as between private citizens, so as to alter their contractual rights and obligations. This conclusion is supported by two Strasbourg Commission decisions, D. Palmer in the United Kingdom and Wood in the United Kingdom, while subsequent Strasbourg court decisions suggest that Article 8 may be engaged on the making of a possession order in favour of a private sector landlord against a residential occupier, there is no support for the proposition that a judge in such a case is required to consider the proportionality of the order which he would have made under legislation such as the 1988 Act. As to the second issue, it would in any event not be possible to read Section 21, subsection 4 of the 1988 Act in the way contended for by the applicant. A declaration of incompatibility under Section 4 of the Human Rights Act would have been the only remedy if the appellant had won on the first issue. As to the third issue, the cases in which it would be justifiable to refuse, as opposed to postpone, a possession order must be very rare, and could only be where the landlord's interest in regaining possession was heavily outweighed by the gravity of the interference with the occupier's right to respect for her home. On the facts of this case, it seems likely that the most that the appellant could have hoped for on a proportionality assessment would have been an order for possession in 6 weeks' time, the maximum permitted by Section 89, subsection 1 of the Housing Act 1980. The court is now adjourned.